We take freedom of expression for granted. We say to ourselves, freedom of speech is essential to representative government, to our way of life, to our communities, to our national existence. It's therefore a little disconcerting to remember that for many, many years, freedom of speech was almost exclusively a state law issue. From the time the Constitution is ratified in 1788 until well into the 1920s, free speech issues are not, I repeat, not matters for the United States Supreme Court. There's no clear understanding that principles of free speech are binding on the state governments. That was certainly the case when slavery was being debated before the Civil War, and many other issues are being debated after the Civil War. And it's also true that our modern conceptions of freedom of speech don't begin to emerge until a smattering of cases in the 30s and 40s, and somewhat more attention in the 1960s. If I was to urge you to read one case which summarizes all of this and what freedom of speech came to be, I would suggest the case of Cohen versus California, an opinion of the court written by John Harlan. John Harlan was an Eisenhower appointment to the Supreme Court, and he had the reputation of being the most consistent, conservative skeptic of the Warren Court's ventures and agenda. He writes a lot of dissenting opinions through the Warren Court era. Now, I'm personally grateful to the man because frequently when I was studying constitutional law, my only route to clarity and understanding was reading a Harlan opinion. I wouldn't necessarily agree with what he said or his bottom line, but when I read a Harlan opinion, I'd know what was going on. He was a brilliant, beautiful writer who defined issues clearly, and you can't imagine how valuable that is for a confused law student. He is also an unsung hero of the freedom of speech cause. You'll hear much more about Holmes, whose words are expansive, eloquent, idealistic, and sometimes difficult to define. You'll hear a great deal about Louis Brandeis, a more careful judge who's deeply influential. But both Holmes and Brandeis primarily write dissenting opinions that are not the law until after their service is ended. You'll hear a lot celebrating the contributions of William Brennan, and I would join in that. He writes a lot of opinions, but there is something about the contributions of Justice Harlan that are both unsung and essential to the detailed structure of freedom of expression jurisprudence that has endured. The case that I'm speaking of begins when a young man who's quite angry about the Vietnam War and the draft puts on a leather jacket at home and walks to the Los Angeles County Courthouse, where I used to practice law. The leather jacket includes a slogan, and since this is a program that is designed for families, I'm not going to name the F word, despite the fact I might be conceding too much to the theory of California in the case. But it reads, F word the draft. This is not apparently an incitement to any sort of sexual activity, but merely an expression of emotion about what he thought of the draft. He is observed by a police officer in the middle of hallways in the Los Angeles County Courthouse, which are chaotic, well populated. Nobody's paying attention to him except this police officer who puts him under arrest for violating a disturbing the peace statute. Now you have to consider for a moment what a disturbing the peace statute is. It's a handy statute that all local governments need, but it's primarily used to deal with the local barroom brawl, or walking out in the middle of a public street or a residential community and shouting a lot. So its utility in a case like this seems like a reach, but the prosecutor decides to prosecute. The court with jury decides to convict. And Mr. Cohen, in the great tradition of American history, takes his case all the way to the United States Supreme Court, where his lawyer faces the problem, do I use the F word in the chambers of the Supreme Court? Now, this is an important strategic consideration, because if he fails to use the F word in the Supreme Court chambers, he is conceding a lot to the rationality and reasonableness of California in saying there's something unpeaceful and uncivil and wrong about using the F word in a courthouse. Well, the Chief Justice of the United States, Warren Burger, is a man who is proud to be Chief Justice. He knew he had been cast by Hollywood to be a Chief Justice. He had a frock of white hair, which was always perfect. You know, those of us who are condemned to have salt and pepper hair can only envy the thick, lustrous, glossy white hair that Warren Burger nourished. And so he leans forward and says something that's quite unusual. Counsel, I'm sure you'll know it's not necessary for you to dwell on the facts of this case. We've all read the briefs. We all know what was going on. This was Chief Justice Burger's subtle effort to say, please don't use the F word. I understand, Your Honor, says counsel. The question in this case is whether the words, F word, the draft, on a leather jacket constitute a punishable form of disturbing the peace. And at this point, that lustrous frock of white hair was accompanied by a beet red face with a distinguished Viking countenance and a frown that everybody in the court saw. Burger was, shall we say, irritated for the rest of the argument. And then he makes an effort to try to keep the F word out of the reported opinion in the case, but Harlan also feels it necessary to include it. Well, all of this is background to, one, the relative triviality of the issue. It's one leather jacket. It's the Los Angeles County Courthouse. It's not exactly a public forum. Grand debates about the Vietnam War are not happening there. Trials in the inside of the court are happening, but it's not a big deal. Justice Harlan writes an opinion, and since I've done some justice bashing today, I want to do some justice celebrating. It's an opinion with 7 great virtues. The virtues of the Cohen opinion deserve to be noted. First, clarity. Harlan is a careful, skilled judicial craftsman. He begins by clearly saying this is a case about the offensiveness of the word. This is not a case about conduct. There is a speech-conduct distinction. It is not true that everything you do can be free speech. This is about the word and its emotional impact on people. The second thing he does is important in terms of advancing the cause of free speech according to the ACLU, William Brennan, and Antonin Scalia, who all stand together on this particular point of view. It's important to have categorical, precise principles defining free speech at the core and making these a matter of federal constitutional law. There are some kinds of talk that are not protected free speech. Obscenity, incitement to violence, commercial fraud. The fact that you speak in words does not mean you have free speech. In this case, however, this use of the F word did not fall in any of those categories. Now, the most likely category suggested by California was fighting words. The F word is fighting words. I was in a labor case where my clients were accused of misconduct vis-a-vis some strikers. And their employees who were labeled scabs by the union, I was representing the company, were accused of doing all sorts of mean things, including using the extended finger, a universal symbol of protest, I understand it. There was a whole day of testimony in which the lawyers for the union tried to demonstrate that the extended finger was fighting words. There were cultural reasons for it. There were ethnic reasons for it. There were political reasons for it. There were circumstantial reasons for it. Well, so too, California was trying to say F on the jacket was similar to the extended finger. It was an exhortation or a challenge. And John Harlan said no. However reasonable a theory, however easy it is for a reasonable mind to come to that conclusion, it was not a universal conclusion. Fighting words is for the barroom brawl. The concept of fighting words is for the direct personal insult addressed to the hearer designed to make that person throw a fist. It's the comment about ancestry fueled by alcohol before the barroom brawl breaks out. So fighting words as a category of unprotected expressions is shrunk to a very narrow category, and that's the only basis on which the state can respond. Not a general theory in which every offensive word comes into the category. True, Harlan said next, and this is a fourth virtue, there might be violence, but might be violence and violent reaction and violent retaliation without proof of actual circumstances. There was no indication that fight was near when Cohen walked through the LA courthouse, is an indefinite and certain way of censoring somebody. There might be violence against Martin Luther King walking through a southern city. You cannot let the prospect of violence become a justification for censorship. Fifth, civility. California was taking an unusual position for California. California thought it necessary to legislate for purposes of civility, not a notoriously high priority in California law. But civility they cited and civility they were pursuing, and Harlan said, give me a break. It is not the job of the state to set up a code of etiquette or courtesy to maintain a suitable level of discourse in the body politic. The sixth virtue points out the dangers of all of this. California's rationales allow a boundless field of regulation. First the F word, then the D word, then every other word with some other sort of initial it has to be referred to euphemistically. And before we're finished, the language is cheapened and stripped, and you have a whole lot less opportunity to say what you mean. Yes, it's one word here, but it could be lots of words. And we don't want to have a beginning of a series of words you cannot use in general discourse. The seventh virtue, I think, is at the core. America goes farther than any other society in defending speech for extremists. Every other free society in the world balances. They allow swastikas to be banned in Germany because of their history. They allow certain kinds of ethnic talk to be banned because of the ethnic culture and the potential for violence. Harlan says, we believe in free speech as an outlet. We believe in free speech for purposes of expressing emotions as well as cognitive ideas. And if we didn't, there would be the danger of an ideological discrimination that prevents the passionate at the margins of our society from talking. And we don't want that. They might throw bombs as an alternative. We want a free speech that leaves a wide latitude for public expression. In this case, in addition to the clear, technical, useful toolkit that he provides to justices, you see a well-developed, mature theory of free speech that has been a virtue of American jurisprudence ever since. Thank you.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.